The new frontiers of law in the digital age, international contracts and the legislation that is applicable and can be applied in practice. Today we are discussing this. I work extensively on an international scale. Perhaps that is where my greatest expertise lies. Consequently, I frequently encounter situations where foreign lawyers, such as those from London or the United States, or even companies, reach out to me directly. They often express their interest in engaging my services, stating that they have made the decision to establish a subsidiary in Italy or to have their own representative in Italy. The most recent case occurred to me at the very end of last week, and it is a case that we are currently handling. And what should the attorney do? The initial step you should take is to try and comprehend the operation that will be conducted in Italy. So what type of activity will that particular individual be involved in during their time spent here in Italy? Will he work as a freelancer? He will work as an employee? He will work as a manager? He will work as a CEO of the company? At what level will he work? What are his skills and characteristics? Or he could possibly also work as an agent. The details of his role and responsibilities are yet to be determined. To understand the activity, go into detail about what this person was doing and what type of activity it carries out. It will need to conduct an assessment in an attempt to comprehend what would be, in essence, the appropriate arrangement of that employment connection in accordance with Italian legislation. And why is that? Because evidently, if that person can be classified as a freelancer, there are no significant problems overall, because freelancers in Italy, I say this as a freelancer myself, are much less protected compared to employees. However, if, on the contrary, that person can be classified as an employee in Italy, then problems arise because employees enjoy more rights, benefits, and legal safeguards that freelancers do not have access to. And for what reason are there these problems? Let's assume that it takes more attention and requires additional focus. Why do we require additional attention? Because we are all aware that in Italy, dependent employment is highly safeguarded and Italian legislation is quite appealing, meaning that Italian law stipulates that if you have an Italian individual working in Italy, for instance, there are high probabilities that this individual is subject to the legal jurisdiction of Italy. And an Italian employment contract is acknowledged. What is the meaning or implication of this? This implies numerous things. This signifies that payments must be made, for instance. This indicates that you additionally have to adhere to workplace safety regulations. There can also be criminal risks, not solely civil ones. And this, of course, means that you cannot easily terminate or dismiss an employee, because if you fire them, if you dismiss them, then you discover that you couldn't do it. And therefore, this entails a whole series of significant economic aspects and considerations. What is my contribution? When a foreign company decides to come to Italy to make an investment and decides to hire its own people, I say it in a simple way. Here in Italy, it is not enough to say, work for us. Here it says that the applicable registration is the English one, and therefore we are fine like this. Regardless of whether the answer is affirmative or negative, we must pay great attention to this type of contracts, because it is both possible and likely that I have the employee sign that contract, but it is also possible and likely that it has no value according to Italian law, and that the Italian judge can say, if asked, that what the employee, the company, has signed does not interest me. In this case, I am obligated to apply Italian law with all the risks and responsibilities involved, which underscores the importance of careful consideration and adherence to legal guidelines.